All right, so I have had the opportunity to review the agreement, and obviously there are some things I wanted to kind of review and cover with you all, just to ensure that we're all on the same page. Obviously, we want this deal to go as smoothly and as efficiently as possible, with keeping our interests as the buyer at the forefront. With that said, there are two particular sections that I would like to review with you, as I have made some suggested additions and or modifications that will best serve our needs. Number one is I wanted to identify any business or legal risks that may be present in the language itself. Number two, what are the probable consequences that would occur should any of those risks were to happen? And number three, what specific actions as the buyer would we take as a result of those risks happening? Okay, so I'm going to share my screen and pull up the agreement. Okay, and we're going to highlight two particular sections number 3 and number 6. I have bolded the font to make it a little bit more legible for you. All right, and so let's look at section number 3, which reads conditions. Obviously, conditions are important as they represent future events that are uncertain to occur. And what we want to do is put measures in place to ensure those certainties to some degree. Okay, so for example, if we look at 3A, it reads buyer's satisfactory completion of due diligence. Okay, so due diligence, we completely know what that term means. I think all parties understand what goes into due diligence. But as it relates to satisfactory, it's important that the seller understands our scope of work, and that it's somewhat of a cooperative project, meaning that there needs to be a firm understanding that what goes into our due diligence may rely on them to give us the document and the data that we need to do just that in a timely and kind of formal way. Okay, so I wanted to make somewhat of a list or outline the specific or some of the specific terms or processes under due diligence that we would be doing. So number one is value of assets, title to assets, liabilities buyer to assume, transfer of assets, future operations of assets, terminated assets. Okay, these are some of the major portions of due diligence that we want to make sure that we relate to them when it comes to satisfaction. And so outlining these particular elements of due diligence will remove any ambiguity as it relates to the condition of satisfaction. And it also prepares the seller to prepare or organize the criteria that we need to do just that. Okay, let's jump to B, buyer's receipt of cash proceeds from financing transactions contemplated by commitment letters attached to this letter in an amount necessary to finance a transaction. Okay, I'm going to stop right there, because funding this transaction, I think we're all in agreement that that is a critical portion or part in moving this deal forward or completing this deal. And so without that funding, we cannot proceed, as I know it, with this transaction. That needs to be relayed in this agreement. So I've itemized some portion of that so that can be certain of what this particular section or condition is. Number one is financing to be subject to a specified list of liabilities to be paid by the seller as a condition prior to closing. Okay. Number two, financing is subject to a firm lending commitment prior to closing, and without adequate financing approval, this deal can and will be terminated. So that is a key portion that both parties need to understand. Upon completing or moving forward with this merger, we need to secure financing from our lending partner. Number three, all due diligence and negotiating expenses incurred by both parties will be self-cured. in the event of a contractual termination, okay? So obviously this deal represents a win-win for both parties, and that each party represents or carries its own weight, should you say, when it comes to making this deal happen. If we jump to C, the board of directors and stockholders of buyer and seller approving the transaction, okay? So board of directors, obviously, terms can be different, but that may not exclude any of the people that may be deemed important to this transaction or signing off on any way for this transaction with the seller. That may include advisors, board of trustees, executive board, whatever they call their board. We want to ensure that we get that consent from them, okay? So I want to clarify that. If we look at section E under 3, the receipt of any regulatory approvals and third-party consents on terms satisfactory to the buyer. So regulatory approvals are very important, and we just wanted to highlight when it comes to any third-party consents. Obviously, third party is a broad statement, and we just want to clarify that for them just in case it kind of jogs their memory. That may include financing partners or silent partners that they have been working it with previously, unbeknownst to us. Number 2, obviously regulatory agency and FTC and DOJ. And lastly, any copyright rights that other parties such as PBS and their TV show rights that they have. We want those type of consents as well. All right. Last, section F, each of the name of key employees entering into employment agreements with buyer on terms agreed with the buyer. So if we key employees, okay, so again, this is broad, and some employees, whether they're executives or non-executives, could be key employees, and we may want them to allocate which employees they deem key and which ones are not. So I suggest that we represent, or when it comes to key employees, anyone who is signing some type of non-compete or has any proprietary intelligence that would somewhat disrupt this deal before and after the deal is made. So I want to clarify that for both parties, okay? So that's section number 3. Let's go to section 6, which is covenants of the seller, okay? So covenants are very important. So these are the things that that the seller must do prior to signing, or that the buyer or the seller must do. For this particular concept, we're going to focus on the seller's covenants, okay? So during the period from the signing of this letter through the execution of the definitive agreement, the seller will, number 1, conduct the business in an ordinary course in a manner consistent with past practice. 2, maintain its properties and other assets in good working condition. And 3, use its best efforts to maintain the business and employees, customers, assets, and operations as an ongoing concern in accordance with past practices, okay? So I wanted to highlight a couple areas here in 1 and 2 that I have added, okay? These covenants, again, mean that the seller must do or refrain from doing anything that could interfere or disrupt the process in the period between signing and closing, okay? Number 2, failing to meet these standards of liability and obligation could constitute a material breach and potentially terminate the agreement. That's strong language, and I intentionally want to put that in there because if there's anything part of this contract that is completely out of our control and that could go haywire, are not adhering to these terms that we have outlined in the covenants, okay? So I wanted to make sure that the seller, as well as us, obviously, we're on the same page when it comes to wanting to make this work and ensuring that we're putting our best foot forward to actually make this happen. And that includes adhering to these covenants. That's what I wanted to highlight today. I hope this was helpful. Again, these are just simply recommendations that I suggest either adding or making any type of language modifications that could reflect our interests with certainty. Okay. Again, feel free to for us all to reconnect and continue to keep this conversation going. Okay. Talk to you soon. Bye-bye.